The Occupational Safety and Health Act provides for on-the-spot inspections by OSHA compliance officers and inspectors. Let's take a look. Inspections may occur on the spot or as part of an investigation of a complaint or as part of targeted enforcement in high-hazard industries. In Marshall v. Barlow's, Incorporated, the U.S. Supreme Court held that safety inspectors must produce a search warrant if an employer refuses to voluntarily allow inspectors into their facility. The court also ruled that an inspector does not have to show probable cause to obtain a search warrant. A warrant can be obtained easily if a search is part of a general enforcement plan. When an OSHA compliance officer arrives, managers should ask to see the inspector's credentials. Next, the company HR representative or safety professional should insist on an initial conference with the compliance officer. During the inspection, the officer checks organizational records to see if they're being maintained and to determine the number of accidents that have occurred. Following this review of safety records, the officer conducts an on-the-spot inspection and may use a wide variety of equipment to verify compliance with standards. Many types of violations are cited by OSHA, ranging from the most severe to minimal, including a special category for repeated violations. The most common are outlined next. Although OSHA inspectors can issue citations for violations of the Act, whether a citation is issued depends on the severity and extent of the problems and on the employer's knowledge of them. In addition, depending on the nature and number of violations, monetary penalties can be assessed against employers. The nature and extent of penalties depend on the type and severity of the violations as determined by OSHA officials. When there's reasonable certainty that a condition will cause death or serious physical harm if it's not corrected immediately, an imminent danger citation is issued, and the inspector posts a notice. Imminent danger situations are handled on the highest priority basis. If the condition is serious enough and the employer does not cooperate, a representative of OSHA may obtain a federal injunction to close the worksite until the condition is corrected. The absence of guardrails to prevent employees from falling into heavy machinery is one example of an imminent danger. When a condition could probably cause death or serious physical harm, and the employer should know of the condition, OSHA issues a serious violation citation and may impose a fine of up to $7,000 per violation. Examples of serious violations are the absence of a protected screen or lath and the lack of a blade guard on an electric saw. Violations that could impact employees' health and safety but probably not cause death or serious harm are called other than serious. Violators may be fined up to $7,000 per violation. Having loose ropes in a work area might be classified as an other than serious violation. A de minimis violation is one directly or indirectly related to employees' safety or health. No citation or fines are issued, but the condition is mentioned to the employer. Lack of doors on toilet stalls is a common example of de minimis violations. Citations for willful and repeated violations are issued to employers that have been previously cited for violations. If an employer knows about a safety violation or has been warned of a violation and does not correct the problem, a second citation is issued. The penalty for a willful and repeated violation can be high, ranging from $5,000 to $70,000 per violation. Federal OSHA compliance officers conducted over 39,000 inspections and found over 70,000 violations in a recent year. The most common violations are related to fall protection, hazard communication, scaffolding, respiratory protection, and powered industrial trucks. The construction industry is cited more often than any other industry.